А, Уважаемые дамы и господа, это огромная привилегия начать сегодня работать. Yeah, my colleagues, translation? No? Oh, fine.
Can you hear me? Can you hear the interpretation? So, once again, this is a great privilege to start our business day today with the roundtable concerning lobbying as a legal profession. It is very important that the organizers of this international forum put this issue on the table for discussion. I have given a thorough thought about how to start our business, our discussion, our roundtable. Well, of course, we could start with a good joke. There's so many of them circulating around lobbyists. I've been asking sophomore students who are lobbyists, without referring to any legal status of a lobbyist. Well, the sophomore students gave the following answer. Странно. 1, 2, 3. Can you hear the interpretation? 1, 2, 3, 4, 5. Can you hear the interpretation? No? What's wrong with the... Doesn't work. Something's wrong with the equipment. Это на русский. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2. Let's start again. Let us start again. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. No, the equipment is still asleep. We need some lobbying here to start it moving. All right. So we'll have to wait a couple of more minutes. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3. Well, I believe we can do without interpretation anyway. So I've been asking this question: who is a lobbyist? A general impression of a lobbyist in the eyes of a first-year student was as follows, roughly speaking. They were saying that this is a male, a corpulent man, above average height, well-dressed, pin-strip jacket, a bit tipsy, and plenty of money in his pockets. So this is one portrait, one profile of a lobbyist.
Mr. Bligin asked a student to describe how a lobbyist looks, and not the legal basis, but just the physical appearance of
Yeah,
him or her.
thank you very much.
And the answer was that the person should be slightly overweight, should wear an expensive suit, have a good cigar, a Western eau de cologne, a good cognac, and give the appearance of being quite wealthy.
Yeah, right. Это был первый образ, который они описали. Второй образ лоббиста.
So this was one alternative. Another alternative was something like this. A modestly looking male, thin, with running with searching eyes.
The opposite, someone rather short, rather meager, and always trying to find his way around.
Mr. Schmidt, thank you very much for your help. Возвращаясь, тем не менее, и в этой части Очень важно составить правильное впечатление о задачах.
Indeed, it is very important to have a right impression about lobbyists, about lobbyism, and the people who do that job.
And to describe a real task of the lobbyist in the society. С моей точки зрения, одна из проблем
It is my opinion that
в том, что лоббизм обозначает
one particular thing about lobbyism in Russia, as it is seen in the public eye,
problems in describing of the lobbyism in the Russian Federation, that lobbyism is usually described as the
it is a profession
instrument
which is an instrument for the promotion of private interests.
И, соответственно, это в известной степени проблема конфликта. And this is one of the problem of conflict. Поскольку в обществе существует впечатление о том, что некие общие интересы имеют абсолютный
Lobbyism is perceived as a source of conflict.
general interest have the more value in comparison
Since
to the
public
private
interests
И очень
has a priority over private interests, it is very important to make the public understand that in the final analysis, private and public interests are all in the same line.
in the society, that the general interest consists of different private interests, and the promotion of the private interest is very important. И продвижение частных интересов также очень важно. В этой части очень важно, чтобы у тех людей, которые определяют...
Therefore, it is important that
более компетентное представление...
political leaders, political class, have a right impression and right idea of what lobbyism is.
Complete understanding of the different viewpoints. Второй момент, лоббизм дает очень четкое представление о возможностях.
There's another side to lobbyism, the competency issue.
From my point of view, lobbyism creates the possibility and provides the public with an opportunity to express concerns and also to support public, and also to suggest public support. Также очень важно, очень важная функция лоббизма заключается в том, что он ставит перед политиками, перед законодателями задачу...
Another important function of lobbying is that it is an instrument to tailor your decisions to your particular needs.
To give possibility to check for policymakers their viewpoints and measure twice, cut once. И, наконец, это очень важно, что лоббизм также, как и другая активность, в условиях открытых...
And another important aspect about lobbyism is that this is an activity that makes possible measuring your decisions against public interest.
Impact into so-called open power and create the possibilities for the society to understand
У кого-то
the
работают
decisions
эти хрени.
which
Кто-то слушает нормально, а у кого-то просто
which
это
are
много
made
аппаратов
by
работает.
the authorities. And it is a communication between the authorities and also society. Собственно говоря, на этом я бы хотел закончить свою вступительную...
So this was about what I had to say by way of an introduction. Now I'm happy to give the floor to my distinguished partner, coordinator of our roundtable, Thomas Sussman, director of the American Bank Association.
Thank you. We're going to be a little informal today because in the last week we've added some new panelists and have not had a chance to coordinate some of our remarks and order. So we will do self-introductions, we've decided. I've been involved in Washington lobbying for over 30 years. and now I'm Director of Governmental Affairs for the American Bar Association, representing the interests of the legal profession, the judiciary, and the rule of law interests in the United States. When I say the word lobbying or lobbyist, whenever I'm speaking to a group of students, of young people, any place in the world, the first thing that comes to mind is usually the words influence, corruption, fat cat, special interests, illegal activities, and very seldom does anyone say public education or improving government decisions or citizen participation in democratic government. Even the title of this program, you notice, is lobbying as a legal profession, as if one might think that lobbying shouldn't be, or in some places isn't, a legal, a legitimate, a lawful profession. There are good reasons for this negative image. One of them is, of course, historical, and that is lobbyists have often been involved as corrupting influences in government around the world. And there certainly is still some corruption from time to time, as there is in every industry, business, or profession. But the media especially seem to enjoy magnifying the negative pictures of lobbyists, in large part because of their historic influence over government decisions. And so lobbyists are often waking up to news stories of how lobbyists have perverted a decision of a government agency or a congressional committee. In fact, in the United States today, lobbying has never been more transparent, more honest, more heavily regulated than it is today. Subject to disclosure, you can, on your iPads or your iPhones or your computers now, go to the website in the United States and be able to pull up my records of who I've represented as a lobbyist, what issues I've worked on, and how much money has been spent on hiring me as a lobbyist. Those are all public records available on the internet. And so because of that, and because of the, in large part, the disclosure, the transparency, lobbying has become, in fact, an honorable profession. And in fact, Professor Allard, Dean Allard, has written an entire article that I'm sure he'll discuss this morning on why lobbyists need to be proud of their profession rather than looking for some other name to call themselves public affairs advocates or governmental relations professionals or the like. Now, in the United States, we have over 12,000 registered lobbyists today, and the amount of money that is reported spent on lobbying is over $3 billion a year, and that just includes direct expenditures, not funds for education or for invigorating the membership of organizations or businesses. The biggest spenders in the United States, as you might expect, are the healthcare and pharmaceutical industries, financial services and insurance, communications, technology, and electronics, and the energy industry. But we also have lobbyists for every conceivable interest, and there are very few things that one would do during the course of a day that doesn't have an interest group lobbying on that issue, whether it's riding bicycles or eating breakfast foods or human rights organizations, automobile drivers, not just the automobile companies. Most interests are represented by lobbyists, and that's the way in which they participate in government. And so we have a mature system of regulation and a pride in our ability to act openly and transparently as lobbyists in the United States. Our second speaker is going to introduce herself because I can't pronounce her last name, Natalie, to talk a little bit about the Russian perspective on lobbying, and then she'll be followed by Dean Allard, and we'll continue.
Да, добрый день. Меня зовут Наталья Малямина. Я управляющий партнер юридической фирмы «Иманины партнеры». Мы, к сожалению, как и все, наверное, в России, не можем похвастаться 40-летней.
Like nobody in Russia, we cannot tell that our history is 40 years long, but we are eager to promote on the Russian market well-regulated and civilized lobbying. And as it was already mentioned, lobbying is a rather young notion for Russia. And there is no well-defined notions or definitions of what is a lobbyist or what is lobbying. Lobbying and lobbyism are rather presented in the public consciousness, and very often the definitions are contradictory and even opposite. Lobbyist as a profession is getting more and more clear. Very often a lobbyist is understood as any person who is promoting any interests, including its own interest, in the public authorities and acting under any status. So we as a lobbyist can understand either a deputy to our state parliament who is promoting a bill which is his or her regular duty, or a deputy who is acting under a fee to protect the interest of a certain group. At the same time, a lobbyist can be a professional consultant to whom lobbying is one of his main professional duties, and at the same time a lobbyist can be a person who is trying to get the proper or the required solution with the prepaid actions. One of our deputies said that lobbying is his main business, and it was the acting head of the Legislative Commission, and that's why he introduced a draft law on lobbying. In Russian mass media, you can even see the ratings of lobbying deputies. The principle of revolving doors, when a deputy after the end of his term becomes a lobbyist, is rather popular in our country, and that's why it's clear that before we define or before we start to regulate lobbying in the Russian Federation, we have to give a good definition and to make a distinction between the lobbying in the proper sense of this word and corruption. So lobbying is any legal protection of interest, either your own or a group of persons that you represent, promoting of your company and your business, or the protection of a region or a state which is represented by the parliamentary deputy. But in the narrow sense, it's a commercial activity to interact with the state authorities to promote the interest of the customers. And of course, we should make a clear definition between lobbying and corruption, because corruption is a crime according to our legislation. I think that in the framework of our roundtable, we should rather use a narrow notion of lobbying as a professional activity. And that's why the title of our roundtable is Lobbying as a Legal Profession. But the question still is it illegal? And who is undertaking these professional duties today? A lobbyist is a person who is interacting with state bodies. So the main function is to communicate, to deliver messages, to deliver information to the decision maker, and to defend the justified position of the customers. So I think that some legal activities like drafting of bills or risk analysis for the customer, I'm speaking about legal risks, but this component can be clearly split from the lobbying as such. A lobbyist can be a professional lawyer to whom it will be one of his duties, or a lobbyist can be a PR specialist. But let's say, I have the following question. Why the organizers of this forum put together at our round table two different professions that can be run by two different people? Russia traditionally has a very low or bad legal culture, and our people usually address their questions to top authorities, to the president, to the governors of the regions. And only lawyers today have a proper understanding how the state machinery works, and that's why the lawyers can be efficient lobbyists. At the same time, we don't have quite a clear portrait of a lobbyist. It's not the background, it's not the education, or it's not a personal talent. Lobbying is a kind of willingness to speak, to discuss, to present the customers, and that's why we don't have any rules or any culture of lobbying. And it goes without saying that the majority of Russian corporations doesn't have any regulations of any procedures for lobbying. So even if we try to avoid these bad portrait or bad notions, lobbying is still has a negative perception, and there is no clear-cut borderline between lobbying and corruption. So the lobbying that should be subject to state regulation as any other legal profession should be registered. We still don't have any transparency, any registration, and contrary to US example, we will not have any public records what were the activities and how much funds were spent, and it's still difficult to explain and to justify that if you had a lunch with the state official, it was not a bribe, it was lobbying. So I believe that regulation of lobbying should result in clear and transparent procedures to ensure equal rights to public associations, and that will ensure a reliable feedback channel between the state and society, which is increase the transparency of decision making. Right now, lobbying is very often linked with the violation of antitrust law and anti-corruption law. As an example, I can give the draft law initiated by many banks on the alteration of their charter capital. capital. Well, the antitrust service said that it's a violation of rights and interests of medium and small businesses, because they will not be able to ensure the relevant charter capital for Lombard's operations, and that's why it was overbalancing the situation in favor of large banks. Well, I don't have enough time to give other examples, but still, recently, lobbying is getting more and more civilized in Russia, and it becomes more transparent. And still more and more often lobbying is understood and interpreted as the legal promotion of business. I think that this is what is still missing is the lack of social order for the regulation of lobbying in the Russian Federation, and I think that we should focus on the raising awareness of the society and changing the public attitude towards lobbyism. And I think that our roundtable will make a small but valuable contribution into the development of lobbying in the Russian Federation, because it's not the first time that we try to raise this topic. I would like to use three functions. First of all, thanks for such a concise statement. I'm not going to advocate the laws, but we are all human beings, we are all people. While the exceptions only confirm the rules. I see lobbyists here in this audience, and I can say that they are charming people, but I always meet them in presence of other witnesses. And the legal culture of Russia, or at least the contemporary legal culture of Russia, is only 20 years old. And I think that during this time we have introduced numerous bills and draft laws about lobbying, but they were more aimed on processes and procedures, and there was no such a tricky thing that would attract the attention of public towards those bills. Well, once again, your statement was extremely concise and covered a lot of issues. I do agree that we need definition of lobbyism. But if I come back to our meetings with our American colleagues, members of parliament, and general prosecutor, I can say that the violations in Washington are quite comparable with violations in Moscow, and the general prosecutor of the United States told me that the scope is incomparable. And please, once again, using my position of the moderator, I will ask not to abuse the time limits and try to be as short as 8 to 10 minutes in your speeches.
Good morning. I congratulate this large audience for making the long journey up the mountain to get to this program. And obviously lobbying is very sexy, Mr. Chairman Pilgrim. And I congratulate you and Tom for assembling such a good panel. My mother is always right. This morning by email, she told me, don't say lobbyist, say advocate. And so I am an advocate, guilty as charged. But that, in a nutshell, embraces what we're talking about this morning. That's a very simple, but I think very useful concept that's universal to understand. So I'm the dean of Brooklyn Law School. My colleague, distinguished Professor Lawrence Solon, is in the back of the room, and we're here in part because we want to encourage greater understanding about the rule of law between our two countries and many countries, and we're looking and hope to have an exchange of scholars and students. So I welcome any of you who want to come study at Brooklyn Law School, and we'd be happy to see you. I thought what I would do very briefly, Mr. Chairman, is to talk about why do you hire a lobbyist, and very briefly, what lobbyists really do, contrary to public opinion. Now, you defined the appearance of a lobbyist, and I was with you until you said overweight. Okay. But I do have a rule about appearance for lobbyists, and it's Rule 17 in the Lobbyist Handbook. And that rule is never wear a tie that's more expensive than the suit of the government official you're meeting with. All right, so if you live by that rule, you'll be a good lobbyist. Now, why hire a lobbyist? Now, in a democratic republic, after all, that's a very good fundamental question. Because after all, it's your government. So why should you have to pay someone to help you make your case to your own government? Now, the answer to that question is, and I'm an attorney, and I believe that everybody assembled on this panel is an attorney, we all know that it makes a difference when you're making a case in court or in a corporate deal to have an attorney. We have a saying in the States, show me someone who is representing themselves as their own attorney, and I'll show you somebody who has a fool for an attorney and an idiot for a client. It makes a difference. Traditional attorneys pursue the question, what is the law? So a trial lawyer or litigator pursues the question, what is the law, who wins or loses? A corporate lawyer pursues the question, what is the law, how do you paper the deal, how do you write the contract? An attorney engaged in public policy advocacy, a lobbyist, pursues the question, what should the law be? What should the rule be? And they do so through the various procedures and venues and arenas where laws and rules are made. This is an extremely complex, never-ending policy process. Anything that's done can be undone. The debate never ends. It's continuous, and it's extremely complex. Plus, all governments, no matter how big, all lawmakers, no matter how capable, have limited capacity. They have many, many demands on their time. So just as when you appear before a judge and have only 15 or 30 minutes to make your case, it helps to have a professional know the procedures and how to make a substantive case. So that is why you hire a professional. Now, what do lobbyists do? There is the popular image that lobbyists are somewhat magicians or hypnotists, and that they ply their trade in a very romantic fashion, carrying bags of money, martinis, vodka martinis in one hand, and a cigar in the other. We never do all of those things at once. Now, that was a pretty good joke, come on. In reality, there are at least 7 things that lobbyists do, and I can briefly describe them. And when you hear these, you will see that these are very practical, mundane tasks that are important. You know, you've heard of the 7 deadly sins. Well, these are the 7 deadly virtues of lobbyists. Number 1, lobbyists provide information to the government. This function gets the most attention. It's the most obvious. Frankly, I think it's the least important, because the government has its own sources of information. But it's important to hear from those affected by laws in terms of what is their point of view. Just as important, lobbyists provide their clients with information. The government won't do that. this will never work. This is how long it will take to get what you want. You can't have everything, you must get agreement from other people. In other words, you educate the client in terms of reality. Item number 3, it is when it's transparent, as Tom Sussman described, and open, and fairly played by the rules, it's a competitive process. So the third thing that lobbyists do is they hold the other side accountable. If Tom Sussman meets with a senator, I'm going to meet with him afterwards and tell them why they should disagree with what Sussman said. Sussman will go in to see the senator and say, Allard is coming in here, and this is what he's going to say, and he's full of beans. Fourth, very important, perhaps the most important, lobbyists hold the government accountable. The government doesn't like this, but in a way, lobbyists who are honest and following the rules are guardians of the interests they represent, like lawyer advocates. Harry Truman said, and I think you remember Harry Truman, if you agree with me, the president, you are for the public interest. If you disagree with me, you are lobbying for a special interest. So I will tell you that all interests are special. The fifth thing is the most important in some respects, but it's one that will be obvious when I say it, but it does not fit your impression of what lobbyists do. When you hire a professional lobbyist, you get compliance with rules. Because a professional lobbyist is in business to work as a lobbyist. If they get a reputation for violating rules, then they're run out of town. They don't have a career or a profession. In addition, the rules are extremely complicated, at least in the United States, and I don't expect them to be any less complicated in Russia or in other countries developing these rules. Tom Sussman literally wrote the Bible. He wrote the compliance handbook. It is a very hard book to live by because it's complicated. I recommend that you look at a book like Tom Sussman's book. The sixth thing that you get with lobbyists is that they get compliance from the other parties. This is very important because it's a competitive system. Almost chapter 2 of the lobbyist handbook is that you check to see if the other side is complying with the rules, and if they do not, you report them. Almost all the highly publicized lobbying scandals in the United States were uncovered or discovered either because the press found out about the activities or other lobbyists reported them. And then finally, the seventh thing that you get is civility, deal making. You know, we've heard about log jams in government, but often government is at a standstill, and lobbyists can communicate and work out deals and arrangements between parties that are not prepared to talk with each other. You've heard lobbyists accused of many things, but you've never heard them accused of being bad guys, bad company. So these good, polite, civil advocates are the essence of helping government in a democratic republic work. And I think that's quite enough for now, and I hope that I've given you a sense, maybe a different look and consideration about what the task of attorneys who work as lobbyists complying with the rules is all about. Thank you very much.
Thank you very much, Rick, for brilliant presentation. Yes, and best regards to your mother.
Okay, I'll tell her you said hi.
Я рад представить.
Now I'm happy to introduce the official representative of the Russian Federation at the Federation Council of the Federal Assembly of the Russian Federation, Mr. Yatskin. Good day to you all. Well, I don't feel very comfortable to speak about all the distinguished guests that have spoken already, especially after Nick Allard. There's very little for me left to say. Well, anyway, since I'm a veteran at this round table, I can say that we have picked up good dynamics, good momentum. I'm representing the Russian government of the Russian Federation in the Federation Council, the upper chamber, which is not really an upper chamber. There are no this hierarchical distinction between chambers. Well, anyway, I'm representing the government in the legislative. I would never in my life thought that I would ever be a lobbyist, or would do lobbying. I thought I would be a mainstream lawyer or something like that. However, I came to understanding and to the conviction that something has to be done about normalizing this profession. We have to do something to follow up on the elements that we've just heard from Dick. They be implemented into legal texts. The legal association of the Russian Federation is in business of drafting necessary regulation for future submission to the legislative. The subject matter is in discussion permanently. We've been talking about that subject matter a lot in in public places, in the government, in the legislative. We are still talking about this, and we're going along. Slowly but steadily, we are drafting an outline of the concept, of the philosophy of the lobbying profession. Then what we do, we try to educate each and every responsible bureaucrat in the legislative and in the government that would have any relation to deal with lobbying. There's so many public agencies involved in this legislative work. Therefore, the machinery is running. Just last year, we have created a special unit for the open government. This is a framework where businesses and bureaucrats would meet and discuss issues of mutual concern, where governmental officials would be able to hear the cases brought for the discussion by businesses, by corporations, by whoever. We have mentioned here such thing as an assessment of the regulatory activities. This is a very important public function. Earlier in our life, we've introduced this assessment practice in the government. Duma is right now thinking about introducing this assessment of the effectiveness of its legislative practices and its legislative acts. Similar processes can be seen in regional legislatives, just about everywhere. Therefore, this is a very dynamic subject. So many conferences at every level, including the federal level, that discuss this thing. The understanding, the awareness of importance of these issues is growing by the day. Now, going back to the profile of a lobbyist. Indeed, I am sometimes tagged as a lobbyist for the government, for the public interest in the legislative. In a way, it is true. There has to be somebody who can bring across the message of the government to the parliamentarians, since parliamentarians must take into account the broadest ambit of interests existing in the country. The body of law is growing steadily every year. and many of them are complicated by the corruption element. Therefore, this multilateral involvement of all branches of power and public in writing legal texts is crucial to eliminate the corruption element, to screen legislative acts for that corruption element, to see to the that the rules of fair play are abided by and complied by every actor. I would also like to stress the importance that we have to expand the understanding of lobbying activity into other professions. People very far off legal professions can also be lobbyists, like historians, researchers, and so forth. Thank you. Thank you so much.
When I was preparing for this panel, I went to a folder that said Russian lobbying, and I found in it a set of analyses done by the American Bar Association on draft law on the regulation of lobbying activity for the Russian Federation, May 1995. So you've been at it for a while. And I'd be more than happy to work on an analysis and evaluation to assist you on any current drafting going on. Our next speaker, Mark Kesselman, has a distinguished career in the United States government, in both the White House, the Justice Department, and lastly as General Counsel of the Agriculture Department before moving into the role of General Counsel of Frito-Lay and the Pepsi Corporation in Dallas, Texas. He also was a colleague of mine in law practice many, many years ago and has seen lobbying from the perspective of both inside government, the outside lobbyist, and now someone who hires lobbyists. Mark?
Thank you, Tom, and distinguished panelists. So, by my count, we've heard at least 3 mentions today of cigars. And I don't think that the references to the cigars were all that flattering, as if being caught with a cigar was somehow an indication that you were up to no good. You will be reassured to know that cigars, too, have lobbyists. In the United States, they are known as the Cigar Association of America. And I have a fact about them. Approximately 1 month ago, there was a secret meeting in the White House. It involved the Cigar Association of America, officials of the Food and Drug Administration, and administration officials from the White House to discuss regulation of tobacco and cigars. How do I know about this secret meeting? You'll have to wait for just a few minutes. So, we have heard quite a bit of discussion, and I think that our moderator framed this as often a view of the public versus the private interest. And I would actually suggest, that there is often a convergence. So compare the secret meeting at the White House involving cigars and the tobacco regulation. Compare that to a decision being made somewhere in the government. Maybe it's a decision being made inside the Department of Agriculture or another federal agency. And someone who's making that decision does not have enough information to accurately understand how is industry positioned to comply, what will be the true effects on the price of the goods on the public, how will this affect other regulations, and this is when that person somewhere in the government, in the very big government, has many things on their plate and probably not enough time to be able to understand everything about the import and the impact of the decisions that they will make. In the United States, and I don't suggest that, that the system is perfect, lobbying is actually not just something that we value as a public good. It is actually a constitutional right. In the very first amendment to our Constitution, we talk about the freedom to petition your government. And so the task I've been asked to talk about today is the framework for how our various laws interact with each other. But understand that it's undergirded on a tradition that began at the founding of our republic. And if you look at the documents and the debates over our Constitution that were at that time, lobbying was understood, or advocacy was understood, just like the great Truman quote, as the best decisions being the product of a noisy debate by a lot of impassioned people who allow decision makers to come to the right result. So in the US, there are essentially three legs to the stool. They are criminal laws, civil laws, and what I will call other transparency rules and regulations. So I confess I have not read Tom's draft for what another country might do, but I would suggest to you on that uninformed basis that there are three different approaches for a comprehensive system. And it's only when you have the full patchwork of these three legs of the stool coming together that things operate in a way that produces the kind of public discourse that's necessary to inspire confidence. First, the criminal laws are exactly what you would expect, which are outlawing bribery and illegal gratuities. It's very simple, but those laws need to be enforced and they need to be on the books. Second, civil laws. I don't purport to come before you today with the full list of all the civil laws that regulate conduct, but I will suggest that there is sort of one that people think of most often, and that's the Ethics in Government Act, which actually was promulgated in 1978, and it's been amended a couple of times since then. First of all, it regulates conduct during your employment as a government official. There's actually an agency, the Office of Ethics in Government, that regulates, the Office of Government Ethics, OGE, that regulates conduct of government officials and their interactions with outside groups. Most importantly, there are financial disclosure rules. When you are a senior government official, when you apply for the job, you have to fill out a rather lengthy form disclosing your stock holdings, where your spouse is employed, a number of things that are somewhat intrusive to privacy. But it really provides a good starting point. And then every year, as a government official, you update your holdings. Even when you're a lower level government official, while they're not made public, the Office of Government Ethics still sees those financial disclosure reports. The Ethics in Government Act also regulates conduct after your government employment. A couple of the panelists have talked about revolving door, and that applies both to the legislative branch and to the executive branch, or the administrative agencies. And those rules are important because it gives the appearance, at least to the public, that someone's not going to work on a matter, resign their public office, accept a big paycheck, and then advocate to the people who used to report to them for a particular outcome. That is not a possible outcome under the revolving door procedures. The third leg of the stool are what I call other transparency rules. There are many of them in the United States. The most prominent is called the Freedom of Information Act. The Freedom of Information Act. We must give information its freedom. How do we do that? By releasing it from its cage. So when you write a note to the government and say, I would like to see the records about your decision on this particular rule or this particular government action, the government has a duty to provide that information to you as a member of the public unless one of 9 enumerated statutory exemptions apply. And they are quite narrow, and actually under President Bush and expanded by President Obama, there are executive orders which essentially instruct the administrative agencies to give a liberal or broad interpretation of the Freedom of Act disclosure requirements. I would also suggest to you that the internet holds great promise in this era of transparency, both as the number of records that are created and emails transmitted, as well as the availability for government to post information on the web without even having to be asked. You can save your stamp from having to write a Freedom of Information Act letter if the government puts it out there before you ask. It can apply to policy decisions, the background that the government relied upon in arriving at those policy decisions, and it could even apply to things such as calendars. When I was at USDA, we actually had a case in the federal courts about the Freedom of Information Act and whether the agency had to disclose the calendars of senior officials, because there was a request from an interest group who wanted to know who a senior official had met with. And the court ordered the agency that those senior officials' calendars should in fact be released, so the public understood how those people were spending their time. There are actually many government officials, cabinet secretaries, who are publishing their calendars voluntarily now and their schedule of meetings outside of the agency. So it's something that is quite common. So the internet, we believe, holds great promise in the future. So if I have one last half a minute.
You've got to give us the answer to the...
I would like to give you the answer to that question, which is exactly what I just talked about. In the White House, when you go in for a meeting under something called Executive Order 12866, the Office of Information and Regulatory Affairs publishes the list of all the meetings for when regulated agencies come in. So this meeting that many years ago would have been secret is now open for all to see. You can actually go on the White House website and see who has come in to talk to that part of the White House to talk about various federal rules. So if you are looking to keep secret what you are doing, it's very difficult in that environment. And because of the 3 legs of those stools, the criminal, the civil, the transparency, it creates an environment where I think lobbying is not viewed as a 4-letter word, but instead it's viewed for what it is, a constitutional principle that our government is there for the people, that its decisions are the products of input of those whom it governs.
I had mentioned when I started that you could look up my lobbying activities and history of my lobbying on the internet easily. The other thing that you can also look up and link to it, which Mark didn't mention, are any contributions I make to federal officials' campaigns. So that also, campaign contributions in the United States are also publicly disclosed by the Federal Election Commission. And you can link lobbyists to issues working on the Hill and also to campaign contributions to members of Congress for re-election. And a number of the non-governmental organizations do that routinely and come out with reports on industries and how much they spend on lobbying and how much they spend on campaigns. A very interesting element of transparency. Mr. Schmidt, next we'll hear from managing partner of White & Case from Moscow, a German lawyer who's written widely on the Russian business code. I actually read the article that you sent me. I didn't understand it, but it was very academic and erudite. But he also brings a perspective of lobbying from Europe as well. And we're looking forward to hearing from you this morning.
Thank you. Let me just put another twist on that secret meeting of tobacco industry lobbyists in the White House. There was actually 2 years ago a similar secret meeting in the building of the European Commission in Brussels. But it turned out not to be kept a secret. And the result was that the commissioner who had that secret meeting had to step down. Had to step down just for having the meeting. And also in the European Commission there is now a regulation that does actually exclude the tobacco industry as far as possible from lobbyism, and prescribes to the officials that they should have contact with that industry only to the degree needed and only upon full disclosure and making it known internally to the Commission. So whereas the European Union is far, far behind the level of regulation that you see in the United States and is probably trying at the moment to catch up, being transparent is seen as something crucial in the European Union as well. There is when I did also some research, when I prepared, I found a very interesting quotation that should normally be visible now here on this screen, but probably I have to work here with the... So it's visible, but probably not readable because it's too small. The ways countries structure the relationship between politics and economics are so fundamental to the country's identities that they become often the basis for classifying total societies. And I think that is probably true. And I didn't know about the fact that lobbying is something that can be traced back to the First Amendment to the American Constitution, as Mark just said, but I think that probably confirms it. Indeed, having access to the government should be a fundamental right of every citizen. And the question is then, if that is so, how one should regulate such access. As you have heard, there have been various attempts in Russia to formulate laws. The last attempts happened just last year, and the outcome just last December was that the people who worked on that project concluded finally that the conditions in Russia were not right, and that it would probably be too early, and formulated a corresponding recommendation in December 2012. That possibly does reflect reality. I don't want to comment on it. It may be too difficult to regulate an area at this point in time in Russia to even attempt it. On the other hand, of course, there is lobbying. Everybody knows this. Lobbying is in Russia an important aspect of doing business. The fact may be that it is so important that that the attempt to regulate it would be futile, because the result would be that you would regulate the representatives of the bicycle industry, but you may not be able to efficiently regulate the representatives of the steel makers for that bicycle, or of the oil industry, or of other important industries, not as efficiently as you wanted. That may be, but of course, there can be little doubt that in the medium term this should be something that should be pursued. If you now look a little bit more closely at lobbying regulation in Europe, first, one thing one needs to know is that 80% of national laws in the European Union countries derive and are driven by EU law, by EU directives and other EU legislation. 80% comes effectively from Brussels. And there are currently between 15,000 and 20,000 lobbyists active in Brussels. There is now and that's very new since June 2011, a transparency register where lobby groups and lobbyists can register themselves. I say can because it is not mandatory. You are not forced to register, and as a result, only between one third and 1/4 of the lobbyists in the European Union have indeed registered. The rest has not. Now, you do not only register. When you register, you are required to update your register with your work on relevant EU legislation that you monitor, so what areas you are into. You have to publish the financial contributions made in this field. You have to disclose your organizational structure and the persons that are involved on the side of your company. And most importantly, you have to disclose the names of your clients. And this is, of course, something that is not, that's not convenient, as long as you do not have to do it. Once you have to do it, I would have little doubt that compliance would go to 100% very quickly, or close to 100%. As long as you don't, as long as it's not mandatory, of course, it will not happen fully. There is a full-time working group that is led by a so-called Secretariat of Commission and Parliament that consists of 8 full-time officials that implement that register, that work on it day in and day out, and that do checks of the actual activities of lobbyists in the European Union. Initiatives, there are also initiatives in the European Union, but so far no formal laws that shall restrict, as was also already mentioned in connection with the United States, revolving doors, meaning that persons fluctuate freely and quickly between business and government in order to avoid conflicts of interests after they left one job to go to the next one. In addition to the regulations of the European Union, some of the member states in the European Union also have lobbying regulation. Of course, probably all of them do have the first 2 legs to the stool that were mentioned. Not all of them have the 3rd stool, which is the actual regulation of the regulation of the lobbying process itself. In that sense, Russia is by far not alone in Europe in not having such a law, so that's nothing special. But the trend in the European Union is also clearly to regulating the area at the national level. If I may also make one remark out of my work and the work of my firm, in this case not relating to Russia, and I think given the shortness of time, given the fact that here are Russian colleagues present, I should probably not try to comment more on the Russian legislative situation, but I would like to make one comment on my practical experience with lobbying by Russian investors in the European Union. And what I have seen there, and I can obviously not name names, but what I have seen there was surprising to me on several instances. It was always the same. Russian investors are reluctant to use lobbying as a tool when they go abroad. I have no explanation for this, but it seems to be recurring. They place importance, of course, on official relationships with governments, and I'm not saying that there is disregard for the interests of the host country, but they do usually not work with professional lobbyists. So they are not retaining advocates of their interests. They retain us as lawyers, which is good, but they do not often turn to lobbyists who, in conjunction with their lawyers, not only formulate their legal interests, but are able to put them in the political context of those countries in the European Union and of the European Union itself where they invest. And that is and to do that would be of crucial importance, and we always say it, simply because you have to face the fact that although foreign investment is normally welcome, and it's also welcome when it's Russian foreign investments, in the current political climate, yes, there are reservations against investors from a number of countries, and that includes Russia. For example, in the energy area and in some other fields, my impression is that the public is not overly welcome in the European Union for Russian investment. And this is something that needs to be worked on. It's just a reflex, but it needs to be worked on. And the decision makers at all levels in Europe, they see that too, and they have elections. So what is necessary to come up with as an investor from any foreign country, but I'm sure especially from Russia, is to prepare the landscape and to be well represented, to make the case why an investment is in the own interest of the European Union and the respective member states. That's the final remark that I would like to make. Thank you.
And of course, from a lobbyist perspective, we always enjoy hearing about the need and importance for hiring lobbyists when you venture into a new arena. I should mention in the United States, rounding out the legal framework, that we have a separate law for those representing foreign interests, the Foreign Agents Registration Act. And especially if it's a governmental interest in the United States, the degree of disclosure of transparency is even greater than that applying to regular lobbyists under the Lobbying Disclosure Act. Our last speaker, whose name I cannot pronounce.
Доставляет удовольствие.
Меня зовут Анна Середа.
Who is our next speaker? I'm Anna Serebrennikova. I shall introduce myself. Thanks for inviting me to speak at this round table. And I would like to speak on behalf of corporate lobbyists. I am representing a Megaphone company, the mobile communication provider, and I would like to defend the Russian system to some extent and to explain to you the legal framework of our activities. First of all, it's really a burning topic because Russia today is really adopting hundreds and hundreds of new laws because our legal system is really new, and it's important for us to regulate lobbying properly. But I still wonder whether this strict regulation of lobbying is necessary. If we come back to American system and to European experience, and having a look on other countries of the world, we shall see that only few countries have lobbying regulations. In EU members, the focus is made on disclosure, on transparency, on the freedom of speech, and Russian constitution's articles 32 and 33 say that Russians have the same right as was provided by Bill of Rights in US. So when we say let's accept the law on lobbying, but the lobbying is a bad word, why should we follow obsolete examples and outdated legislation instead of being inventive and being more up to date. We have now an open government. We have open committees in Parliament and in the Federal Assembly. We organize open meetings. I'm not a man. I'm not smoking cigars, and I don't wear an expensive suit. It doesn't prevent me from being a successful lobbyist in our telecommunications market, or to lobby the interest of my company. From my personal experience, I can say that we mainly discuss the implications of a new regulation on the economic development and the capabilities and abilities to implement the newly adopted legislation. The third question that is usually discussed and that will be more and more highlighted is the assessment of the regulatory effectiveness. I, being a lobbyist, I can say that the wish of the State Duma and state authorities to interact with business is really there, and we gain extra experience and extra opportunities to defend our positions and to present our objections. So I don't want to start from zero to adopt a new code of lobbyists to create a special body who will monitor, control and regulate lobbying at the expense of state budget. Canada adopted the act on lobbying, and it was frozen nearly instantly because Canada decided that there are sufficient number of institutions who ensure transparency and freedom, and implementation of this new act is an extra burden on the state budget and on the state authorities. So the topic that we have to consider, we have to review, is raising the awareness, improving our culture, or creation of soft rules, such as a code of a lobbyist, some special seminars or courses in educational institutions teaching how to interact with state authorities, how to ensure the proper communication between business and government. I think that the number of legislative acts that we adopt is already excessive, and we should rather focus on the proper culture, because lobbying is a democratic institute. It's a chance for a general public or for a corporation to influence the government, and the public must be able to participate and to join the decisions taken by the government, and lobbying is a good instrument of coordination and collaboration between business and government for the effective regulatory norms.
So this is my basic message. We could continue and go on with explaining what lobbyism is, but this was the basic. Thank you. Thank you, Anna, so much. That was very inspirational. You have a special privilege before male lobbyists. You don't have to smoke a cigar and drink too much. Our next speaker, please. Did you want to say something?
Yes, I thought first that this was is this on? Right. I learned a lot from this panel, especially the last speaker, so thank you for that. I thought it might be useful to very briefly help you look around the corner and have a glimpse at the biggest changes that we see in lobbying around the world. The first biggest change, because a lot of what we were discussing in this panel was the traditional do's and don'ts and the way lobbying has always been done. So the first biggest change is that, to the extent never experienced before, lobbying is done on a global basis, and it involves an international four-dimensional chess game. Not on every issue, but on large issues like financial regulation, climate change, energy, privacy, involving the data flow of personal information, security of data. These trans-border issues increasingly are dealt with multinationally. That's the whole purpose behind moving from a G7 to a G20. And regulators and nation states realize, and I think this is reflected in the Prime Minister's opening remarks yesterday that were very impressive, that unless Washington and Bonn and Moscow and Tokyo and Brussels, for example, move roughly in parallel, then you can't get to where you want to go. For example, for financial regulation, if the restrictions or regulations are not the same or similar, then the capital just flows to wherever there's less restrictions. That's one example. Now, as a result, this does not mean that you just lobby international organizations or multinational, but it means, because they have to move together, that if you want to affect Bonn or Brussels, you can affect Washington. If you want to affect Washington, you move London or Canada or Moscow. And so it's a four-dimensional chess game. That's change number one. Mark discussed the impact of new technology on the way you interact with the government. This is a huge phenomenon. People who used to engage in the face-to-face meeting with lawmakers like Tom Sussman and I are slowly sinking like woolly mammoths into the La Brea pits. Increasingly, you interact with the government electronically. This has at least three consequences that are not fully understood yet. The first is, and this is so in the States, there's the question of whether you run the government the way you run American Idol. You have the capacity to ask voters what to do on almost every issue. Do you do that? Now, this is an age-old question. Sir Edmund Burke, 1774, wrote to the electors of Bristol, saying that he was a legislator and not a delegate. He said, "I owe you not only my toil, but my judgment." So that's one answer. Of course, he lost the next election. But this is an issue that we need to address. The second issue is, with electronic communications, do you treat all tweets and emails alike? This is an issue in the States the government is wrestling with, so that when you have comments on laws, can a well-funded, committed, dedicated minority generate hundreds of thousands of comments and outweigh those of others? The third issue is the one of access to equal opportunity and democratic participation. What do you do about the people who do not have information technology or the knowledge on how to use it? The final change is that there is a shift in thinking about lobbying from the corruption model to the fairness model. Corruption, we have criminal laws. We know how to deal with that. In fact, you see those cases in the stories. Really, there's a shift to securing more transparency and less asymmetry. Transparency means that sunlight is a wonderful disinfectant. The professional lobbyists prefer to move in the open and know what the other parties are doing. And the most unusual thought is this. The real problem is that not that there's too many lobbyists, but that there's too few. The more lobbyists you have, the more the less asymmetry you have, the less undue influence, and the more every side, every voice can be heard. So those are the big changes I see around the corner.
Thank you very much. And, в нашем листе есть еще господин Олег Румянцев. Олег Германович присутствует здесь. У нас нет микрофона, займите мое место.
Спасибо большое. Осталось очень мало времени.
Thank you so much. We are out of time. I'll try to be short. The constitutional aspect is very important. It is very important for the basic regulation of our profession. I am a professional lobbyist, and I'm proud to be one. We are very important. We're a very important profession for the public, for the country, and for every stakeholder in the country. Any constitution, our constitution, is based on the principle of fairness, equality. This is our bedrock. Referring to our profession, this means that we must work with the legislation and the legislative class to ensure equity and fairness throughout the body of law and throughout the public polity. Indeed, there is a generally held public opinion that lobbyism is something bad, that this is part of corruption. But now there's an increasing awareness that lobbyists are really a needed profession. What we have at hand right now is only a model law about lobbying activities. However, that law is only technical in its nature. There's no punchline. We need to find that punchline, and we are in the process of finding another solution, and writing another text that would treat and conceptualize the lobbying activities in a totally different paradigm. Prime Minister Medvedev talked about that, and even formulated an executive order to draft appropriate proposals till the month of December. And it was only in December that, having read all proposals, he said that it's too early to legislate lobbying activity. This was a result of a long process. And it was a very reasonable decision to take, because a false step may have dire consequences. Any law that we may eventually adopt must be functional and practicable. I believe that we're still at the stage of discussing things, conceptualizing, visualizing, galvanizing public opinion. In my legal practice in the corporation of Shell, we have discussed the issue of lobbying at the presidential level. Thanks to our specific lobbying activity, we have what we have right now, which is a facility for liquefying natural gas in the Far East. To put my message in other terms, we have to put a message across in understandable and conceivable terms. If an idea is put in wrong terms, nobody will ever buy it. The legal side of the profession is only just one side of it. We need reputation. We need to be philosophers of a business, of corporations. It's a very complicated set of capabilities, talents, and competencies. And finally, a law, a formal and dedicated law, is only part of the story. There's so many laws about combating corruption, on disclosure, on the code of conduct of civil servants, and so forth. But those are only formal things. There's also practice. There's also current activities. And there's always also awareness raising, public perception. Once we work on all those fronts, we will advance our cause more successfully. Thank you.
That brings us to the end of our time, but I did want to mention one issue which the words haven't come up in quite the term, but when we hear the discussion of reputation, even in the absence of laws, lobbyists have a responsibility to act ethically. They have the responsibility to their own employers and clients. They have a responsibility to the government officials that they're meeting. They have a responsibility to society. And it's different from the responsibility that lawyers have. Lawyers are bound by ethical codes, and lawyers are representing private interests, usually where there is a lawyer and a private interest on the other side. Everything a lobbyist does to advance the cause of its employer or client affects all of us. If it's just to get some project funded, if it's to get even a few words changed in a law, it affects everyone, not just a narrow special interest. And so that gives us all responsibilities to act ethically. In the United States, the lobbyists have a professional organization with a code of ethics. In Canada, the government has adopted a code of ethics for lobbyists. And as we move forward to consider the adoption of laws in other countries, that does not let lobbyists escape their fundamental responsibility, not just to do a good job, but to do it ethically.
Спасибо большое, Томас. Мы действительно подошли к концу.
Thank you, Thomas. This was a good resume. Thank you. Anyway, thank you for your fine statements, informative statements, and for the audience. I have noticed that all of you were listening very attentively to what you had to listen. What I think, indeed, terminology and naming things is very important. Petersburg was notorious for promoting one important profession. We used to have a special profession of sweeping ladies that used to clean up the insides of the ships, passenger ships. We found out that nobody wanted to be called a sweeping lady. They wanted to be anybody else, but not sweeping ladies. We had to do something about that. We renamed the profession attendant. We called them stewardess attendants. And that was a very simple solution to a very chronic problem. I think once we rename our profession into something more decent, we will move things along. Thank you again. I'm very impressed by the contributions from our colleagues from across the ocean. Having crossed the ocean and going and crossing all those distances, you have to be very motivated. You really wanted to make a difference. And finally, despite all those language about cigars and martinis, our forum is not a place to promote that kind of products.